We now come to the motion to insist on Commons Amendment 2 and to propose Amendment A in lieu of the words left out by Commons Amendment 2. Minister to move the motion formally.
Formally, Madam Speaker.
The question is that this House insists on Commons Amendment 2 and to propose Amendment A in lieu of the words left out by Commons Amendment 2. As many as of that opinion say aye.
Aye.
Of the contrary, no.
No.
I think the ayes. No. Division. Clear the lobby. The question is as on the order paper. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
The tellers for the ayes are Kate Dearden and Gerald Jones. The tellers for the noes, Wendy Chamberlain and Zoe Franklin. Order, order.
The ayes to the right, 331. The noes to the left, 65.
The ayes to the right were 331. The noes to the left, 65. So the ayes have it. The ayes have it. Unlock. We now come to the Arbitration Bill, Lords, Committee of the Whole House. Order. Order.
Arbitration Bill, Lords Committee.
Can I remind members that in committee, members should not address the Chair as Deputy Speaker. Please use our names when addressing the Chair. Madam Chair, Chair, Madam Chairman or Mr Chairman are also acceptable. We begin with Clause 1, with which it will also be convenient to consider Clauses 2 to 18. The question is that Clause 1 stand part of the bill. Minister.
It's a pleasure to serve with you in the Chairman's notes. On account of the Bill's 18 clauses being grouped together, I will speak to these in numerical order. I begin with Clause 1, which contains one of the Bill's key reforms, specifically provision for determining the governing law of an arbitration agreement. This is important because different governing laws may give different answers to important questions, like who is party to the agreement and whether the type of dispute is capable of being arbitrated. Clause 1 will determine the governing law of the arbitration agreement by replacing the common law approach established in ENCA and Chubb with a new statutory rule. The law governing the arbitration agreement will be the law expressly chosen by the parties, otherwise it will be the law of the seat. By way of simple illustration, if someone arbitrates in London, then by default the applicable law would be English law. Whereas the common law approach is complex and uncertain, the new approach in Clause 1 is simple and predictable. It reduces the prospect of satellite litigation to determine governing law, which can be slow and costly. And where the arbitration takes place in London, as is the choice in so many international arbitrations, then by default the arbitration will be fully supported by English law. For the avoidance of doubt, I would like to add that an express choice of law to govern the main contract, rather than the arbitration agreement, is not enough, and Clause 1 does not apply where the agreement is derived from standing offers of arbitration contained in treaties or foreign domestic legislation, as with investor-state arbitration, for example, as these are better underpinned by international law and foreign domestic law, respectively. Clause 2, 3 and 4 make provision in relation to the arbitral tribunal. Clause 2 requires an arbitrator to disclose circumstances that might reasonably give rise to justifiable doubts as to their impartiality. It applies prior to the arbitrator's appointment when they are being approached with a view to appointment. It's a continuing duty which also applies after their appointment. This codifies the duty of disclosure recognised by the Supreme Court in its decision to Halliburton and Chubb, and will enhance trust in arbitration. Clauses 3 and 4 will reassure arbitrators that they can take the right decisions in their proceedings without fear of reprisal from a disappointed party. Clause 3 provides that an arbitrator will not be liable for the costs of an application to court for their removal unless the arbitrator has acted in bad faith. Clause 4 provides that an arbitrator's resignation does not give rise to any liability unless the resignation is shown by a complainant to be unreasonable. Turning now to clauses 5 and 6. These both concern jurisdiction. There are two ways for a party to question the jurisdiction of the arbitral tribunal. One way is to wait until the tribunal has issued a ruling and then challenge that ruling under Section 67 of the 1996 Act, which allows a challenge to the arbitral award on the basis that the tribunal lacked jurisdiction. Another way is by invoking Section 32, which allows the court to decide whether the tribunal has jurisdiction as a preliminary point. Clause 5 makes clear that if the tribunal has already ruled on its jurisdiction, then any challenge must be brought through Section 67. Clause 6 will provide that where the arbitral tribunal or court rules that the tribunal has no jurisdiction, that tribunal can nevertheless award the costs of the arbitration proceedings up until that point. This will ensure that if a party wrongly starts arbitration, they can still be held responsible for the wasted costs incurred. Moving on to clauses 7, 8 and 9, they deal with the arbitral proceedings and powers of the court. I will speak to each briefly. Clause 7 will confer an express power on arbitrators to make an award on a summary basis, that is, adopting an expedited procedure, to dispose of an issue where an arbitrating party has no real prospect of succeeding on that issue. This aligns with the summary judgments available in court proceedings and will deliver more efficient arbitrations. This power can be exercised on application by any of the parties. The procedure to be adopted is not prescribed. It will instead be a matter for the arbitrator to decide on a case-by-case basis after consulting with the arbitrating parties. Clause 8 concerns emergency arbitrators. Arbitral rules sometimes provide a regime for the appointment of emergency arbitrators on an interim basis. Such arbitrators can make orders on urgent matters, such as preservation of evidence, pending the constitution of the full arbitral tribunal. Emergency arbitrators were not commonplace when the 1996 Act was drafted, so it's important that we now expressly empower them. Clause 8 will provide that failing to comply with an order made by the emergency arbitrator will have the same consequences as those for a normal arbitrator. Clause 9 concerns interim court powers exercisable in support of arbitral proceedings. Under Section 44 of the 1996 Act, the court can make orders in support of arbitration proceedings on certain matters. For example, taking of witness evidence, preservation of evidence, sales of goods and interim injunctions. Clause 9 will amend Section 44 to make it clear that such court orders are also available against third parties. So, for example, the court would be able to make an order preserving assets against a third party like a bank. This will mirror the position in court proceedings. Clauses 10, 11 and 12 all concern powers of the court in relation to an arbitral award. An arbitral award can issue an award on whether it has jurisdiction, and it can issue an award on the merits of the dispute. Either type of award can be challenged under Section 67 of the Arbitration Act 1996 on the basis that the arbitral tribunal did not have jurisdiction. Clause 10 will equip the courts with the full suite of remedies for Section 67 challenges. When the court has a jurisdiction challenge in front of them, they will have two new options: to declare the arbitral award to be of no effect, or to return the matter to the arbitral tribunal for consideration so that a revised award can be made. These remedies already exist for other challenges, for serious irregularities and appeals on points of law. So this provision fixes somewhat of an inconsistency in the 1996 Act. Clause 11 also amends Section 67. It will confer powers for rules of court to provide that, unless necessary in the interests of justice, there should be no new grounds of objection and no new evidence put before the court, unless it was not reasonably possible to put these before the tribunal. The amendments made to Section 67 by Clause 11 also provide that evidence taken by an arbitral tribunal should not be reheard by the court. This will avoid these challenges from becoming full rehearings, departing from the precedent set in the case of Dalla and Pakistan. Rehearings can involve duplication of time and costs, and it can be unfair to allow a party who lost before the tribunal a complete rerun. Clause 12 amends Section 70 of the 1996 Act, which governs how arbitral awards can be challenged before the courts. It will clarify that the 28-day time limit for such a challenge will start running only after any arbitral process of appeal or correction has concluded. Clause 13, Madam Chair, concerns appeals from High Court decisions and corrects a rare drafting error in the 1996 Act. Section 18 of the Senior Courts Act 1981 and Section 35 of the Judicatio Northern Ireland Act 1978 were amended by the 1996 Act. When read at face value, these sections currently suggest that High Court decisions made under the 1996 Act can only be appealed to the Court of Appeal if expressly permitted in the 96 Act. Very happy to give way.
Chris Vince.
I thank the Minister to give way. It's very clear from what you're saying, from what the honourable gentleman is saying, my honourable friend is saying, that this is obviously a bill that is welcomed by the legal sector. I wonder what engagement the Minister has done with the legal sector and relevant stakeholders.
Minister.
I thank my honourable friend for that intervention. There has been massive engagement with interested parties in this bill. This bill began under the last Parliament, and I thank the work done by the last Parliament on this bill. And it began in the Lords, and the Lords engage fully with parties at that stage. And then the Lords have had to redo that in the new Parliament. So they've had two bites at the cherry. And certainly all the feedback has been very positive from stakeholders. I thank my honourable friend for drawing that out in this debate. So just to recap, when read at face value, these sections currently suggest that High Court decisions made under the 96 Act can only be appealed to the Court of Appeal if expressly permitted in the 1996 Act. However, the House of Lords judgment in Inco Europe and First Choice Distribution deemed this to be an error. In that case, it was established that appeals to the Court of Appeal under the 96 Act are permitted by default unless there is explicit provision to the contrary in the 1996 Act. Clause 13 now rectifies the original drafting mistake to reflect the position established in this case law. Turning now to clauses 14 and 15, the bill refers to these as miscellaneous minor amendments. Be that as it may, they offer a few important points of clarification and efficiency. Clause 14 amends those sections of the 1996 Act, namely Section 32 and 45, which allow arbitrating parties to apply for a preliminary court ruling on jurisdiction or a point of law. Under Clause 14, such an application will require either the agreement of the parties or the permission of the tribunal. It removes the further requirement to satisfy the court on a list of matters. In other words, it streamlines the process. Clause 15 will repeal sections 85 and 87 of the Arbitration Act 1996. These both relate to domestic arbitration provisions, but neither was ever brought into force. So finally, we move to clauses 16, 17 and 18. These cover the administrative aspects of the bill. Clause 16 gives the provisions in the bill the same extent as they have in the Arbitration Act 1996. This means that the bill extends to England, Wales and Northern Ireland so that all three jurisdictions benefit from a modernised arbitral framework. Civil justice is not devolved in Wales, but it is now a devolved matter in Northern Ireland. The requisite legislative consent motion was agreed by the Northern Ireland Assembly on the 9th of December 2024. We are very grateful to the Northern Ireland Executive Department of Justice for their support in this matter. For completeness, I note that Scotland has its own arbitration legislation, namely the Arbitration Scotland Act 2010, which is not affected by this bill. Clause 17 makes commencement provisions such that the substantive provisions of the Arbitration Bill, namely clauses 1 to 15, will come into force on such day as the Secretary of State may by regulations appoint. And finally, Madam Chair, Clause 18 establishes the Bill's title once in force.
Dr. Kieran Mullan.
Thank you, Madam Chair, and I rise today to contribute to the committee stage of the Arbitration Bill on behalf of the opposition. I want to begin by again thanking Lord Bellamy, the previous Conservative Minister who introduced the bill originally in the Lords in the previous Parliament, and also to recognise the work of the Law Commission. This bill and much of its work is based on the excellent work that they had done in considering the original legal framework around arbitration. Again, we fully support this bill's objective of modernising and strengthening the UK's arbitration framework. Arbitration is a vital pillar of our legal system, supporting businesses, individuals and international commerce, whilst reinforcing London's position as a world-leading hub for dispute resolution. It's important that this legislation is as robust, effective and fair as possible. The committee stage presents an opportunity to ensure the bill delivers on its promise, and we welcome the improvement it introduces. I don't intend to go through the entire bill and all of its clauses, but just to reassure the House that the necessary scrutiny that you'd expect at committee stage from these benches is taking place. I'll just touch on some of those key clauses. Firstly, in Clause 1, the bill provides welcome clarity on the governing law of arbitration agreements, particularly in light of the Enker v Chubb case in 2020. Defaulting to the law of the arbitration seat where no choice is specified increases certainty for businesses. Secondly, in relation to arbiter immunity and resignation, Clauses 3 and 4 extend arbiter immunity to protect them from liability unless bad faith is proven. This is an important step to ensure that arbiters can act independently without undue fear of litigation. We must retain an effective safeguard to challenge an unreasonable resignation and welcome the Minister's reassurance that parties affected by an arbitrator's resignation are not unfairly disadvantaged. Thirdly, regarding jurisdictional challenges and costs in Clauses 5 and 6, the bill streamlines the process for jurisdictional challenges. Parties will either need to seek a preliminary ruling from the court under Section 32 of the Arbitration Act 1996 or wait to challenge jurisdiction under Section 67. Fourthly, in terms of procedural innovations which are covered in Clauses 7 to 9, the introduction of summary disposal of claims is an important step towards greater efficiency, though we would welcome reassurances from the government that they will monitor its use so that we can be sure it's applied carefully and fairly and doesn't have any unintended consequences. We believe that the recognition of emergency arbitrators is a positive step that enhances the availability of urgent relief, aligning the UK with international best practice. Also of note is the right of appeal in Clause 13. There was, as the Minister stated, an unusual previous drafting issue that suggested appeals to the Court of Appeal were only permitted if expressly allowed under the 96 Act. This was incorrect. Clause 13 now corrects this, ensuring that appeals are permitted unless specifically restricted. This was a vital amendment to uphold fairness and legal certainty. Before I conclude, I also want to acknowledge again an important issue raised in the other place by Lord Hacking, whose contributions to the discussion on arbitration have been incredibly valuable. I know other members have also pressed for greater scrutiny regarding how confidential arbitration could be misused to conceal corruption. We welcome the Minister's assurances that arbitral institutions are taking steps to mitigate these risks, and we believe that the government must remain actively engaged in monitoring and addressing potential abuses and not rule out taking further action at an appropriate time if it becomes necessary. Beyond the issue of corruption, there are other crucial areas that were mentioned in the other place and that are important and warrant further government attention. These include the need for expedited hearings to prevent undue delays in arbitration proceedings, the role of third-party funding and ensuring transparency and accountability in funding arrangements, as well as the authority to mandate mediation between parties where appropriate to encourage resolution outside of arbitration. The Minister's attention to these issues is essential, and therefore I would welcome confirmation that they will be addressed in due course. In conclusion, Madam Chair, the Arbitration Bill is a necessary and welcome step in ensuring that the UK remains a preeminent jurisdiction for arbitration. However, as with any legislation, its success depends on the details. The opposition remains committed to ensuring that the bill delivers legal clarity, procedural efficiency and fairness while upholding the integrity of our arbitration framework. I commend this bill to the committee and look forward to seeing its rapid further progress today throughout the stages of the bill in the House. Thank you.
Josh Babarinde.
Thank you, Madam Chair. I rise today in support of this bill, which introduces important measures to modernise our arbitration framework. Liberal Democrats welcome the approach in particular that the government has taken in refining the bill's provisions to ensure clarity and effectiveness. Clause 1 is a key part of this new bill, and we're fond of the changes made following the recommendations from the Special Public Bill Committee in the previous Parliament. The committee, for example, proposed removing 2 words to prevent undue confusion, and I'm pleased that the government has accepted that recommendation. In addition, the government's further clarified that investor-state arbitration agreements derived from treaties or non-UK legislation will not be subject to the default rule, which is a welcome step and sensible and necessary in terms of bringing greater legal clarity to the process. I also welcome the 5 amendments to Clause 11, which enable procedural reforms under Section 67 of the 1996 Act. These changes respond directly to concerns raised in the last committee and strike the right balance between efficiency and fairness in arbitration proceedings. Further improvements were made in the other place, where the government tabled amendments to Clause 13 to correct drafting issues which have been mentioned and ensure that access to the Court of Appeal aligns with established case law. These amendments received cross-party support, and I am pleased to reinforce Liberal Democrat support for them today. To conclude, this bill strengthens the UK's arbitration framework by improving clarity, ensuring fairness and refining procedures. We support its passage and urge the House to do the same, and we expect that there will be no problem with that at all.
Minister.
Thank you, Madam Chair, and thank you. I give my sincere thanks to honourable and right honourable members from both sides of this House for their contributions today in what was a succinct and precise debate, but a debate where we all agreed that this is an important step forward. And I'm particularly grateful to the opposition spokesman, the member for Bexhill and Battle, and the spokesman for the Liberal Democrats, the member for Eastbourne, for both of them welcoming the improvements in this place and recognising that the improvements to the bill have been the work of many people, both in the Lords and in the Commons, and from contributions from outside, as my honourable friend reminded us earlier. The honourable member for Bexhill and Battle raised the important issue of corruption. As I mentioned during the bill's second reading debate, arbitral corruption is not the result of our domestic framework, which provides several effective remedies to quash corrupt practices. We support sector initiatives to enhance anti-corruption practices, such as the International Chamber of Commerce's Anti-Corruption Task Force, and we'll push for the adoption of best practices as they are developed. The honourable member for Bexhill and Battle raised third-party litigation issues as well, funding issues. The government has carefully considered the impact of the UK Supreme Court judgment in PACA and has decided to wait for the outcome of the Civil Justice Council review before deciding on whether to legislate. A comprehensive review of the market will allow us to take a wider range of factors into account. Following the PACA judgment, concerns have been raised about the need for greater regulation of litigation fundings agreements and greater safeguards for claimants. This is therefore an opportune moment to review the status of the market. The review is being undertaken by the Civil Justice Council, supported by a wider consultation group of experts across this area. The final report and recommendations will be published in the summer 2025, after which the government will consider the way forward. Finally, I think the honourable member raised the issue or mentioned mandated mediation, so I'll try and pick that up as well. The government agrees that dispute resolution such as mediation has a key role to play in ending disputes more quickly and cheaply. This is why all parties to a small money claim in the county court are now required to attend a free 1-hour mediation appointment with HMCTS's small claims mediation service as an integrated step in the litigation journey. This reform will help thousands of people and businesses each year resolve their legal disputes without the need for a court battle. and we will continue to work to drive the uptake of dispute resolution throughout the justice system to allow parties to resolve their disputes more consensually and at an earlier stage. This concludes my responses to those points raised during the Committee of the Whole House. Madam Chair, I once again thank all those who have contributed to this debate. Thank you.
The question is that Clause 1 stand part of the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. With the leave of the House, I will put the questions on the remaining clauses together. The question is that clauses 2 to 18 stand part of the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Finally, I must propose the question that I do report the bill to the House. The question is that I do report the bill to the House. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order. Order.
I beg to report that the committee has gone through the bill and directed me to report the same without amendment.
Third reading.
Now.
The question is that the bill be now read the third time. Minister, Sir Nicholas Dakin.
Thank you, Madam Deputy Speaker. I beg to move that the bill now be read a third time. Let me first take the opportunity to thank all members of this House and the other place who have spoken in support of this important bill and the reforms within it. I'm particularly grateful for the support expressed at second reading by the Honourable Member for Bexhill and Battle and the Honourable Member for Didcot and Wantage. And the Honourable Member for Eastbourne has added his approval today as well as all the Honourable and Right Honourable Members who have contributed to this afternoon's committee's proceedings. It is encouraging to see enthusiasm on all sides of this House for further improving our already world-leading arbitral framework and the business those changes will generate. I also thank the many noble lords who have given this bill and its predecessor under the last Parliament such thoughtful consideration. Without their input and expertise, the bill in front of us today would not be so finely tuned. I pay tribute to the former Special Public Bill Committee who marshalled expert evidence from the sector, judiciary and the world of academia. That committee was ably and expertly led by Lord Thomas of Cumgeath. I am also grateful to all other noble and learned lords who have contributed to the passage of both arbitration bills in the other place, particularly Lord Hacking, Lord Wolfson of Tredegar, Lord Verdirame, Lord Beath, Lord Hoffman, Lord Hope of Craighead and Lord Mance. I wish to give special mention, Madam Deputy Speaker, to Lord Bellamy, who first introduced these important reforms to Parliament as Justice Minister under the previous government. Of course, we owe a debt of gratitude to the Law Commission for their exceptional work reviewing the Arbitration Act 1996 and recommending the reforms being taken forward in this bill today. Professor Sarah Green and her colleagues at the Commission have led what can only be described as a masterclass in public consultation and law reform. I would also like to give my particular thanks to Dr. Nathan Tamblyn for his work leading the Commission's review and the support he has subsequently given the Ministry of Justice in taking forward this legislation. I think it's fair to say, Madam Deputy Speaker, that no one knows the arbitration bill better than Nathan. His contributions to this area of the law will no doubt have a long-lasting and positive effect. This bill has also benefited greatly from the input of experts and practitioners from across the arbitration community. Their contributions were made both through the Law Commission consultations and during evidence taking by the former Arbitration Bill's Special Public Bill Committee. As has been recognised by both houses, it is vitally important that our modernised arbitral law works effectively in practice. This has been made possible by the involvement of those who will use this legislation once it comes into force. Lastly, I would also like to put on record my thanks to the officials who have worked on this bill since it was introduced under the last Parliament. I thank the policy lead, Lee Pedder, and the bill manager, Iona Bonaventura, and Helen Hall from the Office of Parliamentary Counsel. I'd also like to thank my excellent private secretary, Gillian Atkinson. Madam Deputy Speaker, I want to conclude by highlighting again the importance of this bill for the arbitration sector and UK economic growth more generally. We have a proud history of arbitration on these shores, which I covered in some detail at second reading. Since the 1996 Act came into force almost 30 years ago, the UK has been the chosen arbitral location for many thousands of disputes from across the world. In this House can be confident that the modernisations in this bill will enable our jurisdiction to continue playing that vital role for many years into the future. This is very much a growth bill of a growth government. I therefore recommend this bill to the House.
The question is that the bill be now read the third time. Dr. Kieran Mullan.
Thank you, Madam Deputy Speaker. And I just want to say briefly that I join the Minister in the extensive and accurate list of thanks that he put forward, in particular Lord Bellamy, as I mentioned in committee stage, as the Minister that introduced the original bill, and the excellent work of the Law Commission, but others, as the Minister mentioned, Lord Thomas, Lord Hacking, Lord Wilson, and to join him in echoing the effective role and the wealth that the arbitration sector actually brings to our economy because of its world-leading status and the certainty it provides to business and the confidence they have. If they come here, they'll get an excellent service and that they can rely on. And perhaps the final thing I might say is, like most MPs in this House, we've all had that conversation with our constituents where they say to us, why can't you lot bloody agree to stuff sometimes? And or forgive the vocabulary. Why can't you agree with each other more often? And when we turn the TV on, all you ever seem to be doing is arguing. And we know that in DLs and other parts of the chamber, we work together quite effectively. And it's just an excellent opportunity that other members of this House might point their constituents towards in future when asked, for example, in the main chamber, of us working collaboratively together in the national interest. Thank you.
Josh Babarinde.
Thank you, Madam Deputy Speaker, and thank you to all those who the Minister gave rightful recognition to, in particular those behind-the-scenes officials whose work that we don't often see, but without whom a piece of legislation like this would not be possible. Liberal Democrats welcome the Arbitration Bill in as much as it represents a significant step forward in modernising the arbitration process in the UK and enhancing it too. And with over 5,000 arbitrations annually in England and Wales, worth about £2.5 billion a year to the economy in fees alone, arbitration has long been a critical alternative to traditional court proceedings, providing a more efficient, cost-effective and flexible way to resolve disputes. And one of the bill's key merits is its effort to streamline the arbitration process, which can be complex and protracted as it stands. And so by introducing these clearer guidelines and enhancing the powers of arbitrators, the bill can help us secure quicker resolutions, reducing delays and backlogs in the justice system. And this is crucial for businesses who seek fast and decisive outcomes in disputes. And of course, arbitration is part of a wider family of alternative dispute resolution, which helps to take pressure off our courts. And so, recognising this, I'd like to pay tribute to legal professionals and firms in Eastbourne, my constituency, that work day in, day out to facilitate many of these forms of alternative dispute resolution. including Harringtons, Cramp and Mullaney, Hart Reed, Gaby Hardwick, Stephen Rimmer, So Legal, Hobson and Latham, Merwin Baxter, Lawson Lewis Blakers, Cornfield Law, McCarthy Webb, whose services I have used, and many, many more. We are pleased to support this bill for the reasons that I've discussed, but also that many others in this chamber has, and it ultimately helps to position the UK as an attractive destination for global arbitration, reinforcing its status as a leading centre for business and legal expertise, whether that's in the financial capital of the UK or whether that's in the sunshine capital of the UK, and the legal expertise of Eastbourne that I have just alluded to. Liberal Democrats are pleased to back this bill and are proud to support it.
The question is that the bill be now read the third time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes